Hello and welcome to the John Ark Show. Today, we're going to interview intellectual property attorney Thomas Brooke. He's with the law firm of Holland and Knight in Washington, D.C. Before we begin, I want to encourage you to subscribe, like, follow, and comment. We're also going to have a lot of great celebrity interviews coming up, so make sure to click on that notification bell so you can be notified every time we upload a new episode. Also, we ask that you post a link to today's show on all your social media to help spread the word. Now, let's say hello to Thomas Brooke. Hello, Thomas. Welcome to the John Ark Show. How are you today, sir?
I'm doing great. Thanks, John. Appreciate the time to be here.
Good to have you on board. So, Thomas, one of the reasons that I wanted to speak with you today is because we believe that the intellectual property theft in the U.S. and around the world is a greater economic battlefield than most people realize. Mark Cuban himself has said that anything that you manufacture overseas will be stolen and knocked off, oftentimes in the same factory that you manufacture your stuff in. The day shift comes in and they build your product, and then the night shift comes in and they build a rebranded counterfeit copy of your product. That's just the way it is. So my first question to you is, can this problem be solved with intellectual property laws and litigation? Are the laws in and of themselves enough to stop the theft of IP, or should all manufacturing be moved back to the U.S. if you want to prevent the theft of your IP? What do you think?
Well, there's a missing piece there. The laws are actually pretty good. Moving back to the U.S. is a solution, but it's a very expensive one. What you need is on-the-ground enforcement. What you need is to be sure that, you have, if you are an American company or a Western company doing business in China, and we're mostly talking about China, quite frankly, you have somebody on the ground from the U.S. or from the home office who understands the situation, is on top of it, and monitors what's happening, and then have very strong and clear agreements and make it clear to your business partners that they're going to have to play by U.S. rules or Western rules and not screw around with this.
Yeah. Where do we have the greatest amount of IP theft? Is it in the tech sector, the major consumer brands like purses and watches? Is it the pharmaceutical space? Where is the most IP theft occurring? What is your guess?
All of the above. I would say the tech sector continues to grow because everything's tech related these days. Software is so easy to replicate, and it happens here in the States, not just overseas and not just in China. The fashion industry, of course, is screaming about problems, but of course they've done it to themselves by having so much manufacturing done overseas. And pharmaceuticals, that's scary because it's unregulated in a lot of ways, and it's hard to know what comes in those packages that we see on store shelves sometimes.
By the way, somebody was just telling me that some of the pharmaceuticals now, counterfeit pharmaceuticals coming in from Asia, now contain sulfuric acid. Think about that for a second.
Sure. No, there's all kinds of scary stories and all kinds of unpleasant and rumors. I don't know. It's one of those things where you hear stories and see things, but I don't know the truth at this point.
What's most profitable for IP thieves these days, do you think? Is it producing physical counterfeit goods, or is it stealing software products?
Software, because software, once you get the system down, once you figure out how to replicate the code to do whatever it is they're trying to get something to do, then it's just a matter of copying and we're not even talking about hard drives anymore or disk drives. It can be, license fee, set it up so that it's available on your server, and unwitting consumer clicks on it, pays it, and gets the software. And oftentimes they'll never know the difference. But worse yet, what happens is if it's really a conniving operator, in return, the thief gets personal information from the consumer, or even worse yet, gets access to the consumer's system. and can worm their way into my firm's computer system, your computer system. We've heard about all these horrible hacks, and it's often because of just somebody clicking on the wrong link. And these devious criminals manage to worming their way in and exploring what's on your system and every other system out there.
So I'm hearing that they're now manufacturing counterfeit motorcycles in Asia that bear such a strong resemblance to the real brands that the only way they can tell that it's not the real brand is to perform a DNA test on some of the material on the bike. I suspect that their ability to reproduce the look and feel of the real brands will only improve with time. What do you think?
Absolutely. No, we're not dealing with fools or people who are unsophisticated. They're very sophisticated people who know what they're doing and know how to copy this. So again, it's trust but verify. And I don't even know about trust, but definitely verify. Have someone on the ground at the factory level, living in the place where it's happening and monitoring what the factory does at all hours and all times to make sure that this kind of foolishness doesn't go on. And then when it does, alert the local government. The thing about China is there's a lot of problems and a lot of thieves. The Chinese government has turned a blind eye because they're making money off this. What I think in the long run, what we're hoping will happen is that the big companies that have been successful in building quality products like Lenovo computers, Legend computers, other tech brands in China are going to say, hey, you're making us look bad, which is what happened in Japan and Korea 50, 60, and then 40 years ago in Korea. We thought of if stuff from Japan in the 60s is junk and stuff from Korea in the 70s and 80s is junk. But the big brands there turned around and said, hey, we can't have this happening anymore. You, the government, have to crack down on this.
Samsung TVs used to be junk. Now you can't buy an American television made in the United States anymore.
Absolutely. Samsung was not considered a quality brand, nor were a lot of other Japanese brands in the 60s. But it was due to those companies turning to their own governments. And that's, at the end, that's going to be the only solution here. We can complain as much as you want, but it's going to take the Chinese government to enforce their own laws. That's what it's really going to take.
So I'm hearing that some counterfeiters are now using advanced 3D printers to cheaply create counterfeit products like never before. How many American companies would you guess get put out of business each year because of counterfeiting products and they don't even know what happened? They don't realize.
I don't have a handle on that. We hear stories about that. It's certainly it's the small guys that are getting hit the hardest. It's the smaller companies that lose business out of this. Fortunately, none of my clients have had that happen because I think they've had good advice and been careful. But I think it's not the big operators. It's the small specialty companies, especially in like the furniture industry and the fashion industry, that sort of thing. We're not seeing it so much in pharmaceuticals. They're not being driven out of business, but they're just having to change their model.
So, do you ever sue counterfeiters overseas on behalf of some of your clients? And if so, how expensive and how lengthy can that process be?
Well, there's several alternatives, and it can be very expensive depending upon if the other side fights back. Lawsuits in China are very difficult. They're not impossible, but not surprisingly, the local authorities tend to hometown American plaintiffs. But if you've got good information, we've been successful in shutting down infringers using trademarks, using brands, using intellectual property of our clients, mostly trademark side for our practice in China. But it is time consuming more than anything else. And it's tens of thousands of dollars, generally not more than that, but it takes time and it's frustrating. Another faster and preferred alternative is to take action here in the U.S. If you've got a contract, a well-drafted contract, you can bring actions here in the United States it's best to work with partners who have presence in the United States and want more clients in the United States. And therefore, they know that if they tick you off, they're going to lose not only your business, but other people's business. And then, of course, the big marketplace for most of this material these days is Amazon. And Amazon, there are issues with Amazon, but you can go to Amazon if you've got a registered trademark or a registered copyright or a registered patent and say, these guys are knocking us off. Here's proof. Amazon can and should and mostly will take them down if you can prove you own the goods, you own the intellectual property, and these guys are knocking you off. There are other alternatives, but how much does it cost? Tens of thousands, can be hundreds of thousands. Usually, if you bring a lawsuit in the United States, they scuttle away and you get a default judgment and they just go find another victim.
To the small business person who's trying to conduct commerce on Amazon, when they file a complaint against somebody from China who's knocking off their products, is Amazon pretty responsive, or do you need to hire a good law firm to get a response out of Amazon?
It's frustrating. It's hard to get somebody on the phone, somebody to respond to emails. It's all just done through a portal. And the problem we have is that Amazon has set itself up as investigator, prosecutor, judge, jury, and executioner. It takes the whole process by itself, and it's kind of opaque. If you have good documentation, then you should be in pretty good shape with Amazon. But the problem is these guys are generally clever enough more and more to figure out how to just make enough tweaks that it's not an absolute knockoff. The packaging looks slightly different. They'll change a word, they'll do something, and then you've got to make the case. I mean, if you've got Acme brand underwear, and it's clearly Acme brand underwear, open and shut. But if it's something where there's a little bit of a difference, and you know and they know, but then it's going to be a judgment call. And the problem is you can't talk to the judge. You can't figure out what the process is. There's no, unlike federal court, you can't make the case to anybody. You just fill out a form and hope for the best.
As you may know, celebrities out there are now promoting non-fungible tokens or NFTs. Are you seeing much illegal activity or theft in the NFT space yet?
No, but I guarantee it'll happen. I mean, there are a couple of cases out there. And right now, Nike, for instance, is going after somebody who's made NFTs of its shoes. This is a company that actually sells Nike shoes, but has turned the shoes into NFTs. And it's almost a test case. Hermes has gone after people who have turned ties into NFTs and other apparel products. Really, at this point, it's such a new situation that the law is developing. But yes, we're seeing it. And I'm fascinated, and we're all trying to figure it out. But anybody who tells you they're an expert on this isn't. We're all just trying to figure out where to go with it, because this is sort of a new technology. It's not a fungible thing. I mean, if I were to fabricate a fake tie or a fake tennis shoe, clearly that's infringing somebody else's rights. But this is sort of it's not a thing. I can't hold it in my hand. It's just something I can look at on a computer screen. And so it's the question of the law catching up to commerce, which is not unique.
So I know that some celebrities and early adopters appear to have made serious money in the NFT space. But are you seeing many normal, everyday people making real money in NFTs, or are we not seeing that yet?
I don't think we're seeing it. I think there are people out there who are making money and not. The ones who are making the most money probably aren't talking about it. That's often the case here. People who just quietly make the money. We've got clients in the apparel, the fashion industry who are trying to figure out how to do this and have made some money, but they're all scared to death that if they don't keep very close control over what they're doing, other people will knock them off. And I think we're all waiting to see what happens in these early cases, the Nike case and the Hermes case, see how successful they are in stopping people using their materials. I think the courts will figure this out. And once there's some clear guidelines for everybody, they'll move forward. A lot of it is also still trying to develop a market for this. It's a niche thing right now. And I don't see average consumers buying NFTs yet, but you know, we have I have plenty of files and ideas and clients with ideas, and we're working on them.
So I've heard that the reason the Asian companies purchased and own most of the commercially popular home DNA testing kit companies is because they can scan the DNA of the people who buy their testing kits to look for something with medical benefits that they can then patent or sell. Now, I used to think that people's DNA was their property. And then I heard the Supreme Court rendered a decision this week which suggested, I didn't hear the entire story, but it suggested to me that if you purchase one of these kits and you use it and you mail in your DNA, that they have the right to the IP of that. Have you heard about that? Do you know anything about that?
I don't know a lot more than what I read in the funny papers, but you're absolutely right. It's if you've signed up to work with these people, with the DNA testers, you've given them a license to use your DNA for additional research. They're building their databases. And so, you know, the idea is they test me, they test you, they test somebody else. They figure out what our database, what our DNA looks like. They use that to build sort of a additional superstructure, and it gives them, for their original business model, a pretty good idea of who's out there, what we're like, where we're from. You know, we see enough of these chromosomes, all right, and there's great medical benefit to it. If you see the same chromosomes over and over again, and these people don't get cancer, or these people always get cancer, I mean, that's great information.
What part of the patent application process makes it so expensive and time consuming? I would think that in this digital age, it might be a little faster and cheaper than it is. What are your thoughts?
Fortunately for my clients, I don't do patent applications, so I just talk to my colleagues who do that. But it is expensive and it is time consuming, and the time consuming problem is because there's so many of them. They've really, both the trademark and the copyright side of the Patent and Trademark Office have been overwhelmed with applications, and there's only so many examiners and trained examiners to look through them. They have beefed up and hired more people to do it, but it's a question of stuff coming through the door and sorting it out. Right. Why is it so expensive? Because they really have to compare. If I file an application, patent application, or a trademark application, you need to compare it to what's already on the books. They aren't just going to rubber stamp it. And especially in these highly technical fields, whether it's pharmaceuticals, whether it's DNA research, whether it's software or something else, you need people who are experts to go through it, check it out, see what they're claiming, and then compare it to everything else that's already in the database. So it takes time. We joke, but we're not only half kidding. Our goal when we're talking to our clients is to get them the broadest protection possible, and the examiner's goal at the Patent and Trademark Office is to give them as narrow protection as possible. That way, it's easier for the patent office to check it off against the next guy. And there's a lot of negotiation and back and forth. We're claiming, no, this does everything under the sun. And they're saying, no, it doesn't. It only does that. So that's why it's expensive and time consuming.
By the way, is that patent information, is that all digitized out there, or are these manual searches?
No, it is all digitized these days. Everything's online. The patent examiners have access to all kinds of information. It's kind of fascinating. And, you know, the average person can look at most of it at the uspto.gov website. Good luck understanding some of the technical language, but it's all out there. And engineers patent agents, patent applicants are crawling through it every day, all day, all night.
Generally speaking, not your firm, but generally speaking, can one acquire a simple patent for between $5,000 and $10,000, or is that not realistic?
I would say a simple patent could probably be acquired for maybe that much, that little, maybe a little bit more. We used to say you could do that. Again, it's not something I personally do, and our firm is a large firm. I mean, you can find a sole practitioner, but it has to be a rather simple process or simple device. If it's complicated software or complicated medical processes, then it's going to be more like $25,000, $30,000. But sure, I'm quite confident that if you invent a better mousetrap, something mechanical, yeah, you could probably get it for $5,000 to $10,000.
I'll tell you something funny. A few years ago, a friend of mine purchased this well-known book, really popular book, How to Patent Your Own Invention. So
Yeah.
it comes in the mail, and it's
Yep.
3 inches thick.
Yep.
And just flipping through that for a few minutes, and he decided against it. So, I know how complicated it can be.
Yeah. It takes a special sort of person to, and there's so many, there's biochemical stuff. There's straight up mechanical, which we like to think of as the Edison type. Hey, I understand how a light bulb works. But most of these days, the patents are biomedical, biomechanical, complex software devices, formulas that the typical liberal arts guy like me would not understand.
By the way, aren't most patent attorneys engineers? I think a lot of them are.
Yes, in fact, that's one of the reasons I'm not a technical patent attorney. I can argue about patents, I can write agreements for patents, and I can boil something down so that the average person understand. But you need to have either a bachelor's of science or an engineering degree or a master's in engineering or science in order to become a patent attorney. You have to take a special patent bar exam in order to be a licensed patent attorney. And I cannot and have not.
Right. Now, do companies still patent their products in Asia, or do they just not bother anymore because they think it won't really help against IP theft there?
Absolutely, they do. They do patent them in Asia, and they patent them all over the world. I mean, the big operators, the big tech companies, whether it's hardware companies like IBM, which is still one of the biggest owns more patents than I think almost any other company. Still, and Yahoo or whatever it's now called, Alphabet, which is Google's company, and Oracle and all the big software companies certainly have patents all over the world. As I said, that the laws are good in China, and they will enforce them. It just takes time and patience and finding the cockroaches. That's the real issue, is finding the bad guys and then getting the local prosecutors involved. So yes, absolutely, they get patents there, and they also get trademarks on the brands. The nice thing about trademarks is they last forever as long as you keep renewing. Patents do have a limited time period.
Right. In your experience, if you had to guess, out of every 1,000 Americans that gets a patent, what percentage of them do you think gets rich off that patent?
Oh gosh, maybe less than 1%. I mean, there's lots of patents that go nowhere. Unfortunately, a patent is really a hunting license. You get a patent, and then you can hunt after infringers. The big companies, the big corporations will go after people, but the average person can't afford multiple lawsuits. We've had clients who have obtained patents on low-end, inexpensive devices, products, consumer goods that retail for $20 to $50 a piece. Well, just getting in the courtroom is $10,000, and then on you go, spending money on lawyers. It's not worth it for a small, low price device or invention. Oftentimes, the value of the patent is the psychic value and the marketing value. I have a patent on this. you should buy it. It's unique because we've got a patent. It's also an asset. You can go to financiers and say, look, we've got a patent. Lend us money, and if we don't pay you back, you can take our patent away from us. So that's often the only value of a inexpensive device type patent.
Now, I've heard that some intellectual property is so valuable that the inventors choose deliberately not to patent it because they fear that the information in the patent application will make it easier for others to steal or counterfeit. Is that a real world possibility, or does that really not happen that often?
That is absolutely true and quite common, especially in the tech industry, because if you file a patent application and you get it through past an examiner, it becomes published. I mean, all the patents we're talking about, you can go online and look them up, and they're all available for review. If you can understand them, they're all online. The pending patent applications are online once they've been published by after examination. And the other problem is they have a limited term. It's 20 years from application, and then it's dedicated to the public. The Constitution calls for these arts to be dedicated to public use. So the way a lot of these companies operate is it's a trade secret, closely held trade secret. Employees, vendors, customers have to sign non-disclosure agreements. They have people who are employed simply to enforce the privacy laws. So again, if you're working with a vendor overseas, the best approach is to have somebody on the ground watching the shop, somebody from the home office, to make sure there's no foolishness.
What do you think about provisional patents? Are they effective?
They're effective you can't go to court with one. They are a way of putting down a marker and letting the world know that you're going someplace with this. But,
so you say you can't go to court with one. I thought they were of value for 12 months, and then they sort of vaporized.
Yeah, but if 12, unfortunately, the legal system doesn't move that fast. So,
right.
So they're not going to long term, not really.
Gotcha.
You should, again, with every caveat imaginable about I can't give legal advice here with you here, but the value in them is to put down a marker and let people know you're moving forward and warn people off from knocking off the idea.
Well, before we wrap this up, is there anything you would like to promote?
Well, I think what I like to promote is the idea that, from my view, oftentimes the most important thing you can do is, again, strong agreements and then branding for a lot of these things. The most important intellectual property for a lot of inventions, a lot of ideas, is create a strong brand identity that, if I want quality educational television, I will want to watch the John Ark Show because it's developed a strong reputation for quality programming. And you build a following around whether you're selling television programming, legal services, or tennis shoes or widgets. The idea that this is the best place to get it from. And that's what Amazon's done. That's what Microsoft has done. That's what most successful companies, oftentimes their most important intellectual property is the brand, that they know quality. There's a quality company with quality people that stand behind it. If I purchase something with that brand on it, I'm going to get quality good or service.
Well, using the John Ark Show as an example proves you are a man of outstanding taste, sir. So I have to tip my hat to you there.
There you go.
Do you want to let the public know what your law firm's website is?
Sure. It's Holland and Knight. We are www.hklaw.com. So we're a very venerable firm based. We're all over the country. We started in Florida, but we are all over the United States and in a few other countries. And we do it all, including intellectual property.
Well, thank you once again for coming on the John Ark Show and being so generous with your time. And you're always welcome back on the show, my friend. Bye-bye.
All right. Well, I'd love to do that. I mean, we'll see what happens in what we're studying NFTs and the metaverse and trying to figure out Is it worth it? Is this just like Second Life was a few years ago? Or is this a real opportunity for people?
You know, I'm just reaching here, but I suspect there's a lot of profitable litigation in your future in the NFT space.
Oh, I would think so too.
Okay. All right. Bye bye.
Thanks.